Judiciary Thursday morning, January 15th. And we are going to take some additional testimony on H 541. And we have Sally Ober, Town Clerk of Lincoln, joining us. Thank you so much for being here and being willing to talk to us. And if you could identify yourself for the record and proceed.
Great. My name is Sally Ober. I'm the town clerk in Lincoln, Vermont. And so just ready, here we go. Good morning and greetings, Chair Lalonde and committee members. Thank you for considering this important topic of interference with election officials and the process of voting. Voting is part of the foundation of our democracy, and we must be ever vigilant to protect it. I am here today as a member of the Vermont Municipal Clerks and Treasurers Association. It's VMCTA for short. It's a big mouthful. Our mission is to provide education, mentoring, advocacy, and more to town and city clerks and treasurers of Vermont. Our VMCTA Executive Board just very recently adopted a resolution condemning interference and threats toward election officials. And I will read that statement to you now. The Vermont Municipal Clerks and Treasurers Association strongly condemns threatening, harassing, bribing, or interfering with election officials, either while performing their duties or outside of work hours. We also condemn threatening, harassing, or interfering with the lives of their family members, pets, or close friends. Election officials perform their work under oath to uphold the laws of their state and of the United States Constitution. Injurious acts toward election officials will not change the outcome of a vote. Anyone with a complaint about the acts of an election official should follow the procedures of law as required by 42 USC section 15512A and 17 VSA section 2458. Our association was prompted to adopt that resolution recently because of some repeated activities that are going on. And I'll give you some examples of those activities. And I just want to make clear that what I'm about to share with you is my personal experience. I have been serving as an elected town clerk in Lincoln for nearly 20 years. I consider my job of running elections to be among my most important duties. Elections are run locally in Vermont, and the results matter nationally. For all of my life, I expected that the elections in the United States were run freely and fairly without tampering. When I became a town clerk in 2006, my assumptions were confirmed. Town clerks and local election officials take their jobs very seriously, and we do everything in our power to run elections according to law. In my experience, our laws are set up well to ensure election integrity. It wasn't until 2016 that my assumptions were rattled. Just days before the November general election, I received a disturbing email with about a 7-page manifesto informing me that there was a CIA terrorist cult in Vermont, and if I didn't pay attention, people were going to die. This message was so long and involved, I barely had the capacity to read the whole thing because we clerks have a lot to do in the final days before an election. I was alone in the office and it really upset me. I didn't know whether to dismiss this email as junk or do something. Because it involved threats of death to unknown persons, I reached out to our Secretary of State's office and reported it. When I tried to block this sender, they sent me another similar message from a slightly different email address just before the next federal election. Since 2016, I now have come to expect to receive some sort of disturbing or time-consuming message in my inbox before federal elections. One year, all Vermont town clerks got an email about registering someone to vote. This person had a very complex story and said that they wanted to vote for a certain candidate. The complexity of the question prompted some clerks to ask for advice on our Clerks Association online listserv. We found out that every clerk in Vermont got the same emailed request. Some of them said that the person wanted to vote for candidate X, and some of them said for candidate Y. It felt like we were all being tested on how we would respond. We got the director of elections involved, and clerks were informed to disregard that message. Taking the time to respond to this fake request interfered with our election preparations. Before another election, clerks in Vermont got emails informing us that our vote tabulator machines were corrupted and we should cancel the election because the results would not be valid. This sent many clerks into a frenzy trying to figure out how to handle the situation. Canceling an election is not within the authority of town clerks, nor is it within the authority of the Secretary of State. The way to invalidate an election is after the fact by following a legal complaint procedure. In 2024, a threat came much closer to me personally. A voter whom I know came into our office with his adult son to pay his taxes before the general election. He often gives me a hard time about elections, and this time he told me that if a certain candidate won the presidential election, there would be war, and he would send his son to fight. It wasn't until after they left that I wondered whether I was being included as a target in this war. I don't know if this voter is connected to the other email threats that I get, but this one felt much more personal, like being right there in my face. I stopped my election preparations to report it to the FBI, which took quite a lot of my time. All of these incidents are distracting from doing the work that we clerks need to do to be well prepared for running free and fair elections. Making the penalty for interfering with election officials more than a misdemeanor will hopefully be a greater deterrent for people to disrupt our work. Threats and interference toward election officials and volunteers can drive out good people from doing a very challenging but important job for our country. I hope H 541 can help. I thank you for your time and consideration of my testimony, and I would be happy to answer any questions.
Thank you very much. Questions for Sally?
I have one.
Yeah, go ahead.
Thank you, Chair. Sally, thanks so much for your testimony today. After you reported the incident to the FBI, and I'm sure that must have been a really, really terrifying experience, right? Something that you're not accustomed to, especially after your years of service to the town of Lincoln. I'm curious if you reported to the Secretary of State's office and if they had a response.
Yes, I did share with them, and I actually just wondered if I should report it. So they were the ones who encouraged me to
Sure.
take it to the FBI. And I guess what I got out of it was that as a clerk, it's not really my place to decide how credible these threats are. You know, like people can type anything they want. They could just have a bad day and send something out and try to rattle you a little bit. And there may be nothing intentional or real behind their threat.
Right.
And so what I learned was it's best to report, because if this continues, then we'll have a record that this is sort of an ongoing issue with perhaps this particular person. I guess I never really heard much back from the FBI other than sort of what felt like an automated response saying thank you for your evidence and submission. So they never really, I don't think they really followed up and said, yeah, this person's someone we're very concerned about. I think it's just sort of putting it on the record for
Yeah,
the future.
I think that's very important that you did the right protocol as recommended by the Secretary of State's office. And you said that you've been a clerk since the year 2006. Is that right?
Yes, that's
So I
right.
imagine, in the last almost 20 years of service, you've met a lot of other town clerks around the state of Vermont. And I'm sure a lot of them you count as friends. And I'm wondering if the experience that you had in Lincoln is, you feel, and again, this is your perspective, but a more isolated experience, or if it's something a bit more pervasive around the state of Vermont.
I'm not sure how widespread it is in Vermont. I know it's horrible in swing states, and we have spent a lot of our election trainings now preparing for threats and violence. It's that part of it's really disturbing. And the people that came to give trainings are former election officials who said they quit their job of being election officials because people were threatening their children, their grandchildren, their pets, killing their dogs. It was horrible to hear what's happening in other states, and I really don't want it to become a big thing here.
Right.
And there are other clerks in Vermont who actually have to seal off their doors with cameras and locks and only let people in to be buzzed in because of people who threaten them. I know there's one in Addison County who's their door, like you can't just walk into that town office anymore because of the people in their community that threaten the clerk. And I don't know if it's all about elections. It could be about other things that people are upset about, but it's out there.
Yeah, and do you get the sense that it is one political party over the other?
I was told not to be political here. I don't know, but I can just say that, I mean, I think all of us in this room or in that room and everywhere can
Right.
say that the discord in the world of politics has kind of ramped up in the last 10 years. I really don't like to point fingers. I'm a neutral town clerk who
Right.
runs elections fairly, and I have a sense, but I don't feel like saying.
All right.
If
Well, I
that's
appreciate
okay.
that. And certainly as someone on the committee, as an elected official, I've had my own experience with, people in my own town that, whether it's intimidation of public officials and threats and emails and phone calls and texts. So I unfortunately can empathize and relate to your experience and you had to go through that. And I think I speak on behalf of all of us when I say thank you for your service to the state of Vermont, because it really is a very noble duty that you do. And I know the town of Lincoln is very fortunate to have you.
Thank you. I just would also like to point that I'm here talking about clerks, but um, I have a pretty good sense that there are also threats towards our state election officials. I don't know the details, but I get in conversations, we're close with our Secretary of State's office and the elections team. And I know past election officials have had some pretty disturbing things happen to them. Um, I'm not in any place to share details about that, but it's not just town clerks, it's our state officials too, and they need to be protected just as well.
Absolutely. Thank you.
Thank you very much. Any other questions? Not seeing any. Thank you so much for taking the time to testify today. Really appreciate it.
Thank you.
Thank you so much.
Thank you. I think I'll hang on and hear what others have to say.
Excellent. Yeah, welcome to do that. Welcome to do that. So we're going to turn to Judge Zone next, if we can. I know it's a little out of order, but I see that you're here and available now. So over to you, Judge.
So good morning, Tom Zone, Chief Superior Judge. If I'll just kind of run through the bill, obviously this is policy decisions for the legislature, and I won't be commenting on the policies. If you go to page 2 of the bill, I think it's important to keep in mind that in 2022, the legislature made changes to Title 13 VSA section 1702 that talked about criminal threatening. Subsections E and F were added that tied into election candidates, elections. Subsection E provided that a person who violates the criminal threatening statute with the intent to terrify, intimidate, or unlawfully influence a person to prevent that person from complying with state laws or rules, state court or administrative orders, or state executive orders shall be imprisoned. And then subsection F goes down to talk about if you violate it with the intent to terrify, intimidate, or unlawfully influence the conduct of a candidate for public office, a public servant, an election official. And so I point this out because several years ago, the legislature had went through a process to bring these types of statutes into the criminal threatening. And now it's a policy decision if you want to kind of break that up and put another section that seems to be similar, not the same, similar in Title 17. But I just wanted to highlight that you already have criminal threatening that does tie into a number of actions that relate to elections in Title 13. there is a difference between the Title 13 and Title 17, the proposal in Section 2. Under Title 13, the criminal threatening statutes say that a person shall not by words or conduct knowingly threaten another person or a group of particular persons, and 2, as a result of the threat, place the other person in reasonable apprehension of death, serious bodily injury, sexually assault, and some other language. And I point that out because Section 2 of the new bill, 541, does not have that second clause. And so it changes the conduct. It does not require the reasonable person apprehension or the reasonable person side for the apprehension. It simply just requires the actions. That's a policy decision, but I wanted to make it clear that the legislature, this bill is setting up things that deal with similar conduct that could theoretically fall under both, and you're giving different standards.
Right, and we also had a question, and one of the biggest questions on this bill is the constitutionality relative to the true threat doctrine, and certainly have more testimony. And part of it is that we are basing it off of the federal law and double checking, but my initial check earlier this fall was that that law hadn't been challenged or hadn't been found unconstitutional. And so, yeah, it's slightly different standard in the context of voting, certainly, but I understand what you're saying, and we'll need to look at that a little closer.
Subsection 2, line 16 on page 2, it says a candidate for public office, a public servant, an election official, or a public employee for the purpose of interfering with the preparation or operation of an election. Candidates, I do not believe, prepare or operate an election. They run in an election. So I would take a look at that language, and I don't see that language, that clause is necessary in there, because that seems to be focused on preparing and operating. On page 3, line 3, it talks about the Attorney General's ability under the chapter to take certain actions, or the Attorney General may institute any appropriate action, injunction, or other proceeding. I think you need to change the word injunction. There's not an institution of an injunction. An action, it's an action seeking an injunction or an action seeking injunctive relief. The injunction would be what they're seeking in the action.
Right.
Hey, same page, line 9, under civil investigations. It says that the Attorney General or State's Attorney can have any designated agent or representative. And just to be clear, that any designated agent or representative, that is a very wide berth. In other words, they could hire anybody, not a law enforcement officer, not someone employed by them. They could contract out to anyone to come in and do it. And so that's designating. That designation seems to be without any guardrails for who they can bring in.
Right.
Line 11 talks about written responses under oath to questions bearing upon each alleged violation. So it seems like what that is an attempt to include is basically what we would call in the civil world interrogatories. You put out a question, and then you have the rules. You have to answer it under oath. There's no time frame set forth here for how long someone has to answer them. There's no procedure for the scope, the number, the types of things that are generally controlled by the rules of civil procedure. What this basically would provide is that the Attorney General or State's Attorney could theoretically send out as many as they want and say, you got 5 days to answer them. And so without any guidance here, it could lead to some issues.
Right. Yeah.
Could that just be pursuant to
Sure.
civil?
Yeah, that's what I'm thinking. Yeah. Okay. Yeah. Thank you for that.
On line 14, it says they can then do an in-person attendance they could require of any person having knowledge in the premises. I have no idea what that means. And it's not a legal term that I can think of, but similar to my comments about the written responses, this seems to be saying they can do depositions.
Yeah.
And so it seems to be a cross between allowing almost an inquest type procedure where someone has to show up and answer questions about a matter under investigation in the criminal docket, and civil discovery. And it doesn't seem to land in either one. Then I think I jumped to page 5. Line 3. A person upon whom a notice is served pursuant to the provisions of this section shall comply with its terms unless otherwise provided by the order of a court of this state. So what it appears to be attempting to do with this section is to say you have to abide by it unless a judge says you don't. But you then have to wait to find out, well, it doesn't say anything about my ability to challenge this if I have to abide by it. What are my rights? And that seems to be on page 6, line 4. Any person aggrieved by a civil investigation may seek relief. And so it appears that the intent is to say that someone has to abide by it under B1 unless they do something under subsection D, the first sentence, and a judge says they don't have to do it. So my suggestion would be, if that is the intent, you would possibly want to move what's at the end in subsection D up to the section that talks about you have to abide by it, but here is your right, put it all together. Here are your rights to challenge it. It also uses the phrase aggrieved party. I suppose the aggrieved party standard it's broader than saying a person against whom who's being investigated, but the only person who could be aggrieved is a person upon whom the notice is being served, correct? And if the answer to that is yes, why wouldn't it just say a person upon whom a notice is served? Because the entire chapter seems to be focused, the entire section seems to be focused on someone being served with the notice or to either provide written materials or show up for an in-person under oath testimony. And then finally, the second sentence of subsection D on page 6, lines 6 through 9, except for cases the court considers to be of greater importance, proceedings before superior court as authorized by this section shall take precedence on the docket over all other cases.
All right, that's all right. Well, fair enough.
Can I say anything more on that from?
I don't think
So is that the language that, see, my understanding was this was like current law taken from our campaign finance law under Title 17. So I think that language is hiding somewhere else.
It may be, but if it's hiding, we need to say ollie ollie oxen free. We need to get them out, and we need to.
Well, here's the good thing is that this bill is now on a longer runway because this whole section is going to be worked on so that we don't have essentially equivalent enforcement sections in different places in Title 17. So I think we're going to be in a position to correct that provision right there. So
Is it accurate, Judge Zoney, if my note next to that sentence is just no? That's my paraphrase. So
I would go with that.
okay.
All right. Yeah, we've just been talking about this, whether we say promptly or 10 to 20 days, and this one just doesn't fool around.
This one just puts it right up to the top.
Right. That's it.
Is it? You know
And
what you're
no
doing
weekends
tomorrow.
for you either. Thank you, Mark. Right, any questions for Judge Zoney on these? And I don't say thank you very much. This is all very helpful and gives us things to think about over the next few weeks as
Thank you, Jeff.
we work out that other language.
Sounds good. Have a great day. Take care.
All right, thank you. All right, we'll go with the Kim McManus next. Have we heard from Matt Valerio if he's whether he's not confirmed that he is testifying?
He was confirmed.
Okay, well, see, he,
He just agrees with me, right?
I'm sure that that's the case. I'm sure.
False opinion.
Good morning, everyone. Kim McManus, Department of State's Attorneys and Sheriffs. I'm excited to hear that there's a longer runway on this bill, only because I'm going to bring up a few issues and I don't have solutions for you. I did not have time to kind of give some answers. And I'd like to have that time to be helpful to the committee. But big picture, I've not been able to canvass my department on this bill. However, I feel fairly comfortable and confident saying that we, of course, support anything that's going to make our voters feel safe in being able to express their opinion without any fear or threat to themselves. We do have and I think this has already come up in some testimony, since there is the provision in the criminal threatening statute, if this is a different standard, which it appears to be, it's not that someone has to show fear of death or serious bodily injury. We would suggest defining the terms for intimidate, coerce, and threaten for what you want those to mean in the statute for this situation. That would be very helpful. Of course, if this went through, litigation would parse some of that out. But because, especially around threatening, we have case law and definitions coming from our disorderly conduct statute, our criminal threatening statute, also previously the old probation condition dealing with threatening. It would be very helpful if you all guided us on what you want those terms to mean in this context. And again, I don't have those definitions to offer you today, but I can do a little work on that to suggest some language if you would like. Also, of course, you have your very capable ledge counsel to do that. The other piece that we would suggest, this as written appears to want to capture words, not just words and conduct. And if that's the case, we would suggest adding in the clause that appears in the criminal threatening statute that explicitly says, I'll just get the language, many notes, that a threat and threaten do not include constitutionally protected activity, which will, we think, help some of the issues that have come up around that true threat piece. Because again, we do have language and case law around that, but we think adding that type of savings clause in here would help or be helpful. Judge Zoni pointed out the what standard as far as objective standard for how that person is feeling that threat. That would be helpful, again, to add that reasonable person language in there if that is indeed how you want it analyzed versus how an individual would feel from the behavior. Lastly, wanted to point out, and again, this sounds like a longer conversation for another day when we're revisiting Title 17 and these civil investigations. We just want to note for the committee, our department does not have the bandwidth to do these civil investigations. We do not have the resources to do this. We appreciate that this language was copied from the campaign finance law. I can assure you we are not doing those investigations. We have, I believe, 3 or 4 investigators embedded in our department, almost exclusively doing domestic violence investigation. We just so everyone knows, like, this is not something that we can actively, proactively manage right now. So we just wanted to mention that. But again, it sounds like there's more work and discussion on those sections. So we can come back another time on that.
Yeah, no, yes, yeah, there's going to be quite a bit more work on all this. So,
Which, and again, we support, an additional tool, depending on the facts and circumstances, that this may assist in these areas, but we would like a little more guidance.
understood. Okay. Any questions for Kim? At this stage in this Bill's path? Okay, don't see any. So thank you very much. So Defender General Valerio, if you can join us and. Matt, thank you for being here.
Happy to be here.
Really?
I have a sometimes, kind of flat presentation. I got a feeling by the time I'm done, it won't be as flat. Now I can see.
Yeah. That's important. Well, if you identify yourself for the record and proceed, thank you.
I am the guy who you just said I was. I'm Matt Valerio. I'm the Defender General for the state. And I'm here to look at H541. I've reviewed this. I've had our appellate division review this. Let me say that with this bill, as with any bill or legislation that looks at abridging speech, you are in deep water with ice skates, and you better hope the ice is thick enough, because you're on very thin ice, if any ice, with this bill. Now, I'm sure that other commenters so far have brought up the issue, some of the First Amendment issues that arise when you're dealing with threats, and the difference between a true threat and not a true threat. And I would just note that the interesting thing about this, as compared to, say, disorderly conduct or criminal threatening or that sort of thing, is you're talking about speech here in the political arena. The most highly scrutinized area of speech that there is under our US and Vermont constitutions. It is looked at by courts under a standard of strict scrutiny. Okay. And so it is a very limited area that you can get into, usually requiring some sort of combination of speech and action, or speech and imminent violence or imminent threat of action that could be violent. And as a result, this bill as written, and I know it's as introduced and it's a first draft, and you're going to, beat it to death over the next few weeks, as it should be, to try to weed out the problems, and identify the things that maybe you can protect against. This phenomena that we are trying to, and I think you're trying to look at here, cuts both ways, right? So on the one hand, you have the president decrying the violence of protesters in Minnesota, and saying, well, that's not speech. And on the other hand, you've got people concerned about, like the violence we saw on January 6th. Even maybe that's being rewritten now. But the bottom line is you have that type of violence that clearly was action. But there was also street threats, and we just like two sides, you know? This doesn't just cut against whoever you don't like speaking. And that's kind of the whole point of the First Amendment. The people who you really hate their speech and hate the level of vitriol that they put forth in attempting to kind of get their side across, it's particularly in the political arena, is offensive to people on the other side, people in the middle, sometimes people on their own side. And you've got to be very careful about how you address those sort of issues. This is one of those things where I would urge you, and I don't, maybe you already have done this, but the law school has an expert on First Amendment rights, professor, who I don't know. I have very little to do with the law school, to be honest. But I would suggest that you bring that guy in and have him analyze the bill from top to bottom. I was one of our appellate lawyers teaches at the law school and said, you know, this bill, they're almost thinking about taking it in a civil liberties course and saying, this is your exam question. Point out all the problems from top to bottom, because it is replete with those types of potential issues. I guess I can talk about some of the particular things that I heard Mr. McManus talking about, the criminal threatening statute and the disorderly conduct statute and the areas where we have dealt with threats in the past. One of the things that is important, I think, in this is that you do, to the extent that you can, try to define these terms of coercion and the like, as you suggested. The interesting thing is, if you do it or if you don't do it, it doesn't really matter that much, because ultimately whatever you write is going to be looked at in a given case with strict scrutiny by the Supreme Court, hopefully with the idea of preserving speech. That is the kind of the whole basis of it, right? It's not about making people comfortable. It's about protecting unpopular discourse. And the political arena, as you might know, having been elected, which I never have been, except president of the Bar Association. I don't know if anybody voted against me, but I had to, after I was president. Anyway, that was 20 something years ago, and I don't really remember. In any event, I don't put myself out there like you people have to when you're elected. But our country has a long history of negativity surrounding elections, and if you can go back to the 1700s, and there's some very interesting history around the Adams and Jefferson election and the like. I've brought in some of the cartoons that were written back then that they would violate this statute 10 different ways at that, given their conduct during that time. And it continued. I'm not saying it's good or it's morally right or anything like that, but it survived the First Amendment. So I already talked about the whenever you're talking about speech and not physical actions or a combination of the two, review of strict scrutiny. Kind of sweeping words like intimidation and interference and disturbance on page 2, lines 10 and 11 it seems to be very broad and captures protected speech as well as unprotected speech. it's vulnerable to an attack on its face because it chills protected speech, even though it does carry, gets at the intent. This is that throwing the baby out with the bathwater sort of thing, where you got rid of the bathwater, but oops, there goes the baby, and that's because it has the potential to stop people from doing things that they have every right to do. It would be, as written, invalid on its face, in my opinion. On page 2, lines 12 and 13, and 17 and 18. When you use the words "for the purpose of interfering with the right of another person to vote," what does interference mean in that context? Is it subjective and open to a discriminatory application? What does intimidate mean in that context? If you have a legitimate demonstration against a particular candidate going on, whatever it is, 125 feet from a voting place, and that is causing concern to people who are going into the voting place, can that be intimidating? Sure. Is it legal? Absolutely. I had going back to literally now, 1983. And I was in college at the time, and I was working for a candidate up in Chittenden County. And I had an interaction with a person who I didn't know at the time at a voting place. And the person who I didn't know was kind of pointing me in the face. You get back. You can't, you're trying to intimidate people. You're trying to, finger in my face kind of thing. And, I'm a college student with, lots of energy and some sense, but not enough. I know a lot less now than I did then. And, I'm giving it back. And ultimately, cops come over and they're like, get back. And I didn't realize the person I was arguing with was the Secretary of Administration for the governor. And the governor's detail was asking me to, shut up, basically. And I found out after the fact. They're like, you know who that was? I'm like, no. And they, I just thought it was some person who was, not letting us do whatever we wanted to do. And so I wrote a letter to the Burlington Free Press back when they took letters. I don't know if they do anymore. And they, and I just described what had happened. I said I thought it was inappropriate for people to abridge speech in that way. And then I noted, of course, particularly that somebody who was part of the governor's administration. I got a letter back that said that they weren't going to print it, and it was they perceived it as a personal attack on the governor and their staff. And I didn't even know, apparently the governor was there. I didn't even know that. I was just doing my thing, right? And so these sort of issues are always ones, for me, that have, I've had some personal experience with it, so to speak. And, one of the things I've always believed in is that the Constitution was there to protect things that are unpopular. And that is exactly what the First Amendment's all about. I guess I'll go down to page 3. And this is where you start the the civil portion of things. I know what you're doing with campaign finance and this. This is not the same. This is, again, speech-oriented stuff. And the protections are greater. It's a different kind of speech. In many ways, it's pure speech. And just because you call something civil doesn't eliminate the search and seizure protections that you have under the Vermont and US constitutions. The government is not relieved of its responsibility to get a warrant based upon probable cause just by declaring that something is a civil matter, and particularly when there's the potential for criminal liability, which there is replete throughout this statute. I would note as well that a person cannot be compelled to testify under oath without the right to counsel in a matter that might be incriminating, and on the mere basis that the AG, and I get, yes, I don't blame the SAs for wanting to opt out of this. My guess is that anything that is, criminal is going to maybe be pursued by the AG's office as opposed to the state's attorney's office, although they might work together on these things. But just calling something civil doesn't allow the state to say, hey, I have a reason to believe that a person has been in violation of this chapter, and then go in and look at all your stuff or compel you to testify. There are exceptions. They're very, very discreet on the civil side of these things. Usually it has to do with stuff that is inherently dangerous, like handling of nuclear materials, toxic waste, weapons of mass destruction, and particular audit requirements that have to do with weapons, weapons of war, that kind of thing, where the government has the right under these very, kind of discrete, dangerous situations, that involve mass issues, where they can go in without a warrant and pursue civil remedies. Speech would not be one of those things. All right. So
a question.
Can I just, I don't want to interrupt you
Yeah.
too much. I just want to know, I had the sort of same question yesterday around that, and I was wondering how in the 2042A6 on page 5, line 1 and 2, the non-applicable to criminal investigation carve out for the civil investigations, does that cure this issue at all, or is it is this kind of meaningless?
well, that has to do with the notice.
This subsection shall not be applicable to any criminal investigation or prosecution brought under the laws of this or any other state.
What page are you on?
I'm on page 5.
Oh, all right. I'm sorry. I was on page 4 because there's the
One,
the part that talks about criminal. I think. Yeah, I had a note on that. My note was, this is more evidence that this is a criminal prosecution in sheep's clothing. What you'll note that if there's a seizure that is illegal, not based on probable cause, this actually recognizes that there may be a criminal prosecution that is running parallel to it. And just by, it doesn't help you.
Yeah.
It actually kind of illuminates the issue that you have two things going on. This is let's dial this like way back to something very common. DUI, civil suspension, and DUI criminal, right? All of the same rights regarding due process, search and seizure, and all of that apply on the civil side for a civil suspension of your auto license as they do for the criminal side, and whether you're going to get a penalty, probation, or jail. Same thing, right?
Yeah.
So this is kind of this, what I sub 6 here is what I call the Wizard of Oz provision. And I've seen it some number of times, which is pay no mind to the man behind the curtain. He's not doing this. This is totally different. No, it's the same thing. And actually, when there's also a where it, what I think you have here is this bill is doing everything it can to kind of civilly gather information and then ultimately use it on the criminal side if necessary. And you can't like unknow something or unseize something. All you can do is suppress it, right? Under the Fourth Amendment, or under Vermont's Constitution, which actually provides more protection against searches and seizures than the US Constitution. So let me just I can go through my actual notes and read this crap, but I just said what I just kind of told you what it said without pointing to specific lines in the bill. Let me, however, point your attention to sub 11 or line 11 on page 5 of 6. There's a portion above which says, or maybe even below, that talks about contempt. This is when I get out of line. Oh, but look at let me back you up a little bit. I actually prefer questions usually because then it's easier to just answer them than it is to go through this stuff. But on page 4 of 6, it says such notice shall include a statement that a knowing and intentional violation of this chapter is subject to criminal prosecution. So this is where like the civil part becomes a criminal thing if you intentionally do it. Like I don't know anybody who intentionally doesn't or speaks unintentionally about these matters, especially when it's like in writing and documents and things like that. It just keeps providing more and more evidence that what we have is almost not even a parallel thing. We have a civil investigation that's going to lead to a criminal prosecution potentially. It also in lines 9, 10, and 11 says, anything we seize can't be used or disclosed unless you're disclosing it to the Attorney General, State's Attorney, or a law enforcement officer engaged in legitimate law enforcement activities, which might be what? The criminal prosecution of the exact same activity. All right. And then sub 6, which is the carve out, don't pay any attention to the guy behind the curtain, right? The fine that is talked about here under the civil portion, this is kind of a minor point, but I just wondered, is this a civil penalty or is this a criminal fine? Like what kind of fine is it? I'm not sure, given above, that it matters. And then it talks about any disobedience of any order under this section by any entered by the court shall be punished by contempt. All right, well, we know court, what type of contempt? Is it civil contempt or is it criminal contempt? There's a difference. Is it, and I don't know, a lot of people, even the court, to be honest, many new judges don't really know the law of contempt. They don't understand it because it doesn't come up very often. There's two major types of contempt. Contempt in the presence of the court, like where I call a judge lots of bad names and try to disparage and interfere with what's going on in the court. And then there's then there is contempt out of the presence of the court, which, number one, requires that there be a valid court order, but this says shall be punished as contempt of court. You can't say that this shall be punished because there is discretion and the person who is subject to contempt must have the ability to purge themselves from the contempt. So they have the right to a hearing to show cause why they should not be held in contempt, number one. And then so they might challenge the validity of the order. They might challenge the constitutionality of the order to begin with. They might challenge the due process that gave rise to issuing the order. And then this is kind of ordering the prosecutor in the executive branch to bring a charge, which you can't do. There has to be discretion, and you kind of skip that whole due process part and just says shall be punished. So that whole line's got a bunch of issues.
Chair.
Yeah, go ahead.
I mean, question, you shared that. I just, so it seems like this piece needs a lot of looking at, and maybe there were some pieces that weren't considered or seen. The other piece that I remember asking yesterday is that this was adapted from the piece of campaign finance law. Sounds like maybe there were some adaptations that aren't working out so well. I'm curious your thoughts on the original, what's in campaign finance. Like, does that work for you there? Not saying that we're going to duplicate that. I think the chair said there's going to be like a working group to try to come up with a new version of this. So I'd be curious to hear if you're like, that one is great. So if you stick more with that, like that's going to be, or you're like, that one actually isn't great either. So. Well,
what I'd say is that one is different. Okay. That one is, it's apples to oranges. It's very, can I tell you a story? I was in DC for totally different reason the day that Bill Sorrell went down and argued the campaign finance law at the time before the U.S. Supreme Court. Before I was Defender General, I had this 15-year legal career where I did a bunch of things. And one of the things that I had done is represented movie studios around, around the world, and sales of things and such. And the Anna Nicole Smith inheritance case had gotten to the U.S. Supreme Court and was being argued the exact same day that Bill Sorrell was arguing campaign finance reform. And I was in DC for a different reason, but I was DG at the time. But I'm like, hey, well, I'm here. Why don't I just go over to the Supreme Court and see the Anna Nicole Smith argument? And then I'm like, Sorrell, what are you doing here? He's like, what are you doing here? I'm like, oh, never mind. Because that wasn't, the U.S. Supreme Court had big questions about that version of campaign finance based on First Amendment issues, right? And then we came back and reworked it. And I don't know that there was another US Supreme Court challenge of it. Now, I'm not an expert on campaign finance reform, and to be honest, I am, and those protections and the like. But you can see, all I'm going to say is you can see how even that form of speech is so scrutinized. And this is even a higher level because it is it's speech without action, and it's in a political arena subject to facial challenges and strict scrutiny, like really hard to fashion something. So honestly, no matter what you do here, even if you make some of the suggestions that Ms. McManus and I and me, if you bring in a First Amendment expert in, even if you follow like whatever those suggestions are, you're still going to be on thin ice, because this is one of those things that, in the old days, the ACLU used to jump all over. I don't know that they do it as much anymore. They've kind of changed their focus to some degree, but this is the kind of thing. It's just really hard because you can't legislate around the First Amendment, and then when it comes to searches, seizures, statements, compelling statements under oath, that kind of thing, you can't legislate around the 4th, 5th, 6th, 14th amendments of the US Constitution and our analogs in the Vermont Constitution. So everything you do here is from an academic sort of intellectual legal standpoint, this stuff is fascinating. This is great, but there's a lot at stake, and there's no better time like to be looking into this kind of thing than what we're seeing around the country right now about like what kind of speech is okay, what kind of action is okay. It really does cut both ways. And from an academic standpoint, it's like you're in the lab, right? Unfortunately, there's a lot at stake in the lab right now, and I know you try to get it right. This is just a hard place to get it right.
So so the needle that I see that we are trying to thread, and maybe we can't, is a couple things. I mean, it's really tied with interfering with the right to vote, and it's intimidation, threaten, or coerce. Does that change the possible standard for true threat? I understand that when we're talking about politics, the political realm, the freedom of speech is protected as anywhere. But this is actually interfering with another right, which is the right to vote. Maybe it doesn't change, but the other thing, and part of the reason why we're going through this exercise is that if it's good enough for the feds, because this is modeled after 18 U.S.C. Section 594, then why don't we take a look and dive into it? We may in the end decide that it's not going to work, and we will bring in Rodney Small as an expert in First Amendment law.
Yeah,
but that's kind of why
that's the name I was not remembering, because I don't have anything to do with him. It's but he's the guy.
Yeah,
and maybe it doesn't make enough of a difference, and maybe
you can write it, and what you don't want to do is write it so that it's facially invalid,
right?
And then on a case by case basis, you're going to define what those terms mean, as long as you don't, on its face, go after speech alone, and that's where like the academics in this area are going to be better. And I can, honestly, if I just had a little bit more time, I spent, obviously you can tell I spent some time on this, but if I had a little bit more time, I could give you the list of cases. I could give you the definitions that are in the Vermont case law, where, you have differences between, what kinds of threats are true threats and not threats. And I could go through all of that stuff, just like we did in, was it the 2022, when you changed the criminal threatening statute to add activity. I also wonder why you don't just stick it there. But you know, it just might make some sense from prosecution and defense standpoint. Like when we're looking at crimes, I know we do have these things scattered throughout other titles in Vermont law, but this one seems to be fit right in there. Not that this, kind of fits here too, but that isn't where I'd look if I were trying to figure it out. But when push comes to shove and these things end up getting challenged or defended, I think somebody will find it. So it's not that big a deal. It's just crimes are usually in Title 13. That's all.
Yeah, and part of it, just on that, and you're right, it could be in Title 13. Maybe that's where, if we proceed with this, we put it. But it also is changing. Our jumping off point was Title 17 and some current law related to intimidation and such. Could be either place, but we'll figure that one out too.
Yeah, that's relative to the big issues. That's not the big issue at all. There's probably a sweet spot, and the sweet spot may not be, what you don't want to do is freeze that political speech. You don't want to put people who have something legitimate that they can do and say, having that deterred by the statute. And that's where your problem is, right there on the criminal side. The civil portion of it has a lot of issues.
Yeah, and that kind of got added towards the end, frankly, and I think that we've already heard a lot about that particular component.
Overall, honestly, this is not going, unless something really goes crazy, and I really hope it doesn't, but we're not going to see, we probably won't see 5 of these cases in 10 years. And so it's not going to have a big impact. It's just, when it does, it has big implications for kind of the pillars of what we stand for.
Yeah, no, we have to get that right.
So that's what I have.
Any other questions for Matt? All right. So we have, I've been explaining to people, we have a long runway on this bill, and it keeps stretching even longer, and we'll see if we can get this plane off the tarmac. Oh, come on, it's always a good metaphor. So I appreciate the input on that. And also, I know that you were saying that you're going to provide some written testimony on the animal cruelty bill. You may want to, if you haven't put a bunch of time into that yet, that's going to have a major revision of that bill, I think, given the testimony we've had this week.
Yeah, it's basically done, but
yeah, I mean, I think we'll probably hit the same issues that we've been trying to.
Yeah, some of it. And some of it is kind of the policy side of it, and the kind of impact on both prosecution and defense with these animal cruelty bills.
Yeah, right.
If you don't mind, let me just say something very brief about it without going into the details of the bill. Animal cruelty prosecutions, in particular forfeitures and the care type proceedings that go on right now, are a bane to our existence.
What? The bane for existence?
Yes.
Existed.
The public lawyers, the prosecution, the defense, the court, the people who come in 99% of the time have mental illness issues, even though they're not incompetent. They are indigent. They are transient. And they will fight every single one of them, every step of the way, until their dying breath. And so forfeiture of animals, care proceedings, those kinds of things are akin to back when they used to do it when they, seize cars for DUIs, that kind of thing. And we'd spend $50,000 in legal resources to get a $2,000 beater. We are spending more than that on these cases for the forfeiture of an animal. And, I like animals fine. And I've had animals. My kids like them too, but my kids are older. So anyway, it is a massive drain. Is it a massive drain on like the resources of public defenders and prosecutors? Unbelievable. And if in my career, when I was representing people in court on a regular basis, I could represent somebody charged with murder. I could represent people who had, molested multiple children. Nobody blinks. I represented some dog that got abandoned and had its butt frozen in a snowbank because the people got evicted and they couldn't take the dog with them. Now the dog got unthawed from the snowbank and ended up recovering, which was nice. But I got more talk about threats and death threats and all that kind of thing. I got more of that kind of thing regarding animal cruelty cases than I ever got representing any person charged with murder, charged with sexual assault, you name it. It didn't matter. It's a so hot button, but it takes, I was hired privately by the parents of the woman who was involved in this, eviction from a mobile home kind of thing. It was unbelievable. I'd never seen anything like it. And we spent a lot of resources on that. I do not relish the chance to be doing and having our people do forfeiture and cost of care, proceedings that run parallel and with no contact time-wise with the criminal case that's going on. That's just a general comment on it because it's remarkable in a way I can't even explain to you when these cases come in. And every single one of them gets appealed to the Supreme Court. Every one of them. I'm just telling you. So, that's just that's from like a defender general administering a system and seeing what prosecutors have to do and what defenders have to do. These cases are a resource and nightmare. So, but that, if I'm with
It's complicated in here as well as we are dealing with that bill. So,
there was other stuff in there too that, I really didn't want to.
Well, some of that stuff may change over the.
Yeah. So if it's going to change, I'm glad that I didn't, so basically what you're telling me is just hold off where we get the next draft.
Yeah, I think
something.
Yeah.
It'll be substantively different enough, I think.
Every now and then I'm smarter than I look by not coming in with version 1.
Yeah, sometimes, yeah.
I was good on this one though.
This one, your comments on version 1 are very helpful. So I
Right.
appreciate it.
Well, thank you. And I was happy to be here, to be honest.
Yeah, well, good. Excellent. Thank you for your time, Matt. Really appreciate it. And I know that we have one of your people in this afternoon testifying on H5. So Kate Lamson is going to be, I guess, zooming in probably. I assume.
Yeah, she will be. Only Dick Sears grants every day from Bennington, and he might still be. It's not quite sure, but I love that guy. But boy, was he persistent. In any event, I think you'll enjoy Kate. She was a prosecutor for a number of years, and then became a defender, and so she's seen both sides of this. And
Great. And we'll look forward to
give you a unique perspective.
We definitely need that, and I appreciate that. All right. Thank you very much, Matt. And
thank you.
I believe Allison Despathy will be on her way momentarily. We can go off live but if people can stick around, I think she's on her way.